Hi there, I'm Victor Manibo, one of the attorneys here at Wang Law Office. And once again, you're watching our newest YouTube show, The AM Show.
Yeah, hi, I'm the host Ariel. I'm a senior paralegal in Wang Law Office. Our show going to start every Friday at 8 a.m.
And Ariel, we've been doing this show for about 2 months now. So our viewers probably already know what's going on in the show is that we cover a specific immigration topic every week with all of your questions that we get from our YouTube comments and from email. And I try to, enlighten our viewers on commonly asked questions about a lot of immigration applications. So as always, if you have any questions about immigration that you have been meaning to ask an attorney, please feel free to contact us through those means, and we'll try to batch those questions, and hopefully your questions will make it onto one of our shows in the future.
Before we start today's topic, Victor, can you introduce your background a little bit?
Right. So for those who are new to the show, again, my name is Victor Manibo. I'm one of the more senior attorneys here at Wang Law Office, and I've been with the law firm for 10 years. I've been a lawyer for 12 years, and I graduated from Cardozo School of Law here in New York City. I specialize in immigration cases, of course, and in criminal cases in as much as it impacts people's immigration status.
Yes, and last week we talked about I-601A waiver, but
Right.
there's more question that we will ask regarding this topic. So,
Yeah, I mean, it's a very complicated topic.
So there's more question. One of the question is when we should file this I-601A waiver.
Right. So with I-601A waivers, it's done in conjunction with an I-130 family-based petition and in conjunction with consular process applying for your green card in the consulate or outside of the country, right? So this is a multi-stage process, and a lot of people probably have to think, well, okay, so when do I need to apply for the I-601A, right? And the answer is you have to apply for it after you get your I-130 approved. The petition by your U.S. citizen or LPR relative should be approved, and that petition should be sent to the National Visa Center, and that's when you can start the I-601A process. Now, the I-601A process, like I said, it's a separate application from the I-130, but one of the requirements for the I-601A is you have an I-130 approved. So if the question is when should you apply for the I-601A, that's after you get your I-130 approval.
You mentioned National Visa Center, right? Do I need to inform the National Visa Center that I'm filing this I-601A waiver?
No, you don't have to inform the National Visa Center. This is something that happens independently of the I-601A. Once an I-130 petition gets approved, it gets forwarded to the National Visa Center to send to the consulate where you will eventually apply for your immigrant visa or for your green card. So you don't have to, wait for them to send it to NVC or to notify them, but just know that before you can do I-601A, you have to, get the I-130 approved, and NVC should get your case.
So if I file this I-601A waiver, will it going to change my immigration visa process?
Well, once you file the I-601A, what you need to do is wait for it to get approved first, right? It has to be approved so that your unlawful presence is forgiven. And that's the whole point of the waiver, right? So that if you have if you have this bad thing in your history, the unlawful presence, it gets waived, it gets forgiven. So you have to wait for it to be approved. Now, what happens after that is the immigrant visa processing at the consulate. And so that would be the next step. It doesn't really, I-601A doesn't change anything. It's a requirement before you can get to the next step.
So it's kind of something in between the I-130 after the MVC before your visa process, right?
Before your consular processing, yes.
So what kind of information I should gather for this I-601A?
Right. So last week we talked about what the I-601A waiver does and what the requirements are. If you remember, the requirements are you have to be present in the United States, you have to be at least 17 years of age, you have to have an approved I-130, and also I discussed that you have to show that your removal is going to cause hardship to a qualifying relative. So that hardship to the qualifying relative, that's usually the part of the application that USCIS really focuses on, because that's the biggest part of it, and that's really the hardest part to fulfill. So in terms of information and documents, that's really what you should focus on. What kind of hardships you have for your relative, and what kind of documents you have to prove them. And we talked about the kinds of hardships last week. We can talk about it some more again today. Yes, that's the bulk of information. The bulk of your application is going to be about that. Now, obviously, as someone who knows your family, knows your family members, and the hardships of your family, you probably have some ideas of what documents you need. But this application, like I keep saying, and like with any application with immigration, right, it's very complicated, and there might be hardships that you don't know or you're not familiar with or you don't really think about. So it's always important to, again, consult with an attorney for any application, but especially for this one, because it's an application that has a lot of different ways to show hardship.
Yeah, you find a better lawyer is going to help you much easier. So you mean that I-601A is doing it not only a form, right? It might have so many things that we need to add up to the application.
Absolutely. Like the I-485, like the I-130, like any immigration application that you submit, it's never just a form. It's never just, you fill out the form and you sign it and you submit it and that's it. Absolutely not. You have to have supporting documents, and the more supporting documents you have, the higher your likelihood of getting approved. But obviously you have to submit the right kind of supporting documents, the right kind of proof, and the person who can best assist you in finding the right kind of proof and providing the right kind of evidence is a competent lawyer who has experience in this kind of application.
Yes. I want to know, I-601A, is that applied to other grounds of inadmissibility other than the unlawful person that we mentioned last time?
With applying for a green card or when applying for any immigration benefit, we always, or you might hear of the word inadmissibility, which is criteria that would render someone ineligible to be admitted into the country, or we can't let you in, basically, for certain reasons. And as I was saying last week, one of the grounds of inadmissibility is unlawful presence, and that's what the I-601A waiver is for. That is the only thing that the I-601A waiver can forgive, just the unlawful presence. If you have other problems, if you have other grounds of inadmissibility, like a criminal history or prior fraud in your immigration history, you're going to need a separate kind of waiver for that. We've discussed it in prior episodes. I want to say maybe 2 or 3 episodes ago.
Maybe.
We talked about I-601 waivers. Those are also similar waivers because they can forgive problems in your immigration history. But for I-601A, it only deals with unlawful presence. And like we talked about last week on the I-601A, and I want to stress this also, you have to have no other grounds of inadmissibility when you file for an I-601A. So if you have a removal order, for example, that you need to get waived, you have to get that waived with a form I-212 before you apply for an I-601A.
Yes, and I want to know what could be the procedure for actually applying this I-601A.
The procedure is very similar with how we apply for I-485, for example, or other immigration benefits. You fill out a form, you pay the fees, and you don't pay the fees. You attach your payment
credit card form.
Via credit card, or you attach a check to your form, and you attach supporting documents to your form, and you submit that to USCIS. Once they receive it, they'll process the payment, and they'll schedule a biometrics appointment where they obtain your photo and they obtain your fingerprints to verify your identity. And then after that, they'll process the I-601A application. Now, the processing time for I-601As is taking a while right now. It's over a year. For more specific waiting and processing times, you can go to uscis.gov, and it differs depending on the geographical location of the applicants. So just know that once you submit it and you get the biometrics appointment and you finish that biometrics appointment, usually it takes about a year for some people before you can get a decision. There is no interview for I-601A waiver applications, so you don't have to worry about that. But there is, a waiting time. And of course, because there is no interview, you have to make sure that everything that you submit is already complete. Everything is already, close to perfect, because you have no opportunity to
no second chance.
Right. You can't talk to an officer and say, I forgot to submit this. Here you go. Sometimes that happens during an interview. You can't do that with an I-601A. So it's important that your package is close to perfect or perfect. And the best way to do that, like I said,
Find a good lawyer.
Exactly. Find a good lawyer who knows what they're doing.
Yeah. So you mentioned removal proceeding. So if I am in the removal proceeding, can I file this I-601A waiver?
So one of the things that could be a hindrance to someone getting a green card or from getting LPR status is being in removal proceedings, meaning they have an ongoing immigration court case. And in general, if you have an immigration court case, you're prevented from getting a green card. And that could mean that you might not be able to get a green card through adjustment of status, or you might not be able to get a green card through consular processing. And so it also impacts your I-601A, because your I-601A is a path for you to get a green card through consular processing, right? So how does ongoing immigration proceedings impact your I-601A? Well, under the regulations, if you have ongoing removal proceedings, you cannot apply for an I-601A. So that means if you have a current immigration court case, let's say you have an upcoming hearing in the near future or the far future, as long as it's ongoing, you're ineligible to file for an I-601A. So what you can do in that case is to either get your removal proceedings administratively closed, meaning temporarily close the case, ask the court to admin close, that's the term, admin close the immigration court case, and then you can file an I-601A. Or you can ask the court to terminate the case, ask the immigration judge to completely do away with the immigration court case, and then you can file an I-601A.
So you mean that the people have the removal proceeding is being terminated or dismissed, they can file this I-601A, right?
Right, because if an immigration court case is terminated or dismissed, it doesn't exist anymore. It's gone. So you can file for an I-601A. What is prohibited is to have ongoing immigration court proceedings as you file an I-601A. So if it's either administratively closed or terminated, then you can file for an I-601A.
So what if my 601A is approved, but my court case is just temporarily closed? Do I need to do something before I leaving the country?
I talked about administrative closure as a temporary closure of the case. And this is something that immigration courts do. They temporarily like kind of take a case and like put it on a shelf somewhere and don't think about it. And the effect of that is, the case is not ongoing, and then you can apply for an I-601A, right? Like I said, if it's had been closed, you can apply for an I-601A. Let's say what happens next is your I-601A is approved. And when we talked about this last week, the next step would be for you to go out of the country to do your consular interview and apply for your immigrant visa, for your green card at the consulate. Now, if your case is still temporarily closed when you leave, technically you still have an ongoing immigration court case. It hasn't disappeared. It's just like on a shelf somewhere, right?
So you need to terminate before you leave?
Yes, exactly. So for that case to not be a problem, you have to get the case, recalendared, take that case off of the shelf and back onto the court, and then ask the judge, hey, judge, let's terminate the case. I have an I-601A approved now, and now what I can do is I can go back to my home country and apply for a green card. Let's terminate this case altogether so that I can get that green card, so I can leave. And that's something that we've done for a lot of our clients pretty successfully. Judges, when they hear that you have an I-601A approved, they're very willing to terminate a case so that the person can go back and get the green card, because it's really the final step. The final step is just the interview at the consulate. So judges are very willing to terminate on that basis.
Yeah, we talk about how about that I-601A is denied. And I file it again in the future.
Yeah.
I know this happened, right?
So with any immigration application, generally, if you get denied, you can try again. You can reapply. You lose your filing fee, obviously, and you have to repeat the process and fill out a new form and get the new supporting documents or new copies of supporting documents, and you have to pay your lawyer again, maybe, and that is burdensome. So that's why it's very important to make sure that the first time is the correct time and the only time that you're going to do it. Get it right the first time so you don't have to repeat it again, so it doesn't get denied and then you have to redo the whole thing again, right?
Yeah, getting a good lawyer, that's why.
But the short answer to the question is yes, you can reapply, but hopefully you don't have to, because you did it right the first time.
So there's a lot of people asking the same question. If my 601A waiver is denied, will I going to be deported?
So the question of will I be deported really depends on whether or not you have a removal order. In general, there are some exceptions, but in general, you cannot be removed from the country unless you have a removal order. You don't have status, they can't just deport you. You have to go through a process. You have to get a removal order, typically from an immigration judge, before you are deported from the country. Now, what happens when you have an I-601A? You submit it to USCIS, it gets denied. It doesn't matter if it's denied or not. If you have no removal order, you won't get deported. Obviously, it's a bad thing for you to lose any immigration application. But unless you lose your immigration court case, unless you get a removal order, which we talked about in a previous episode, unless you have a removal order, they can't really deport you. So the two things are unrelated.
So we talk about we apply. So can I appeal to the denial of 601A?
All right. So this is the other option if your I-601A is denied. If any application for USCIS generally, if it's denied, you can do it again, like reapply, or you can appeal. And the answer is yes, you can appeal an I-601A denial. There is a process for this, and there is a separate fee. You have to file what's called an I-290B form, and you have to submit supporting documents. You have to submit a brief that explains your reasons, your legal reasons, or additional proof, so that you can win your appeal, or to say why USCIS was wrong in denying your I-601A. It's basically another application and another application package, but that is also an option. You can appeal or reapply. Now, let's say your I-601A got denied. The question is, okay, so what's the best way for me? Should I reapply or should I deny, right? And the answer to that is my favorite answer: it depends. It depends on the specific situation. A lawyer will be able to tell you which option is going to be more likely to be successful, which option is going to be less time consuming, especially if you have, you have an emergency, you want to be able to get your green card right away. One pathway might be quicker than the other. And, again, and the more important part is the first one is, well, which one is more likely to succeed, a reapplication or a denial? And it depends on the reason why it was denied in the first place. So a lawyer will let you know which option to take. And really, that's why you hire a lawyer, to tell you which the best options are.
So I want to know if I have additional document for my 601A application, but you mentioned earlier that I cannot submit additional document when the case is pending. How about when after the case is denied? During the appeal process, can I insert the additional document there, or I need to reapply to use that additional?
So generally, when you're appealing, you can not add or submit additional documents unless they were unavailable at the time that you previously applied. So if it's completely new documents, you can typically include that with your appeal. New documents. So something that only came up, after you submitted while it was pending, not when something that you could have gotten before and then you just forgot about it and now I'm gonna okay. And again, there are very specific rules about this. Appeals, you can't just submit whatever you want. And this is why, like I keep saying, consult with your lawyer so that you know what to submit the first time around. Everything is complete the first time around.
So if it denied once for the 601A, is that I appeal for the second time, or maybe I reapply for the second time, is that going to be lower my chance of success?
With any successive appeal or any successive reapplication, you have to think about, what am I doing wrong and what am I doing better, right? And maybe the first time you did it on your own, and obviously there were so many mistakes. So when you reapply, maybe it's better because, let's say, maybe you hired a lawyer who knew what they were doing, right? So, but then that gets denied again, and you want to keep trying, right? So you hire a different lawyer who does a better job at it and adds more documents and submits a better brief. The probability of success really depends on each individual case. And there's no point in reapplying over and over and appealing over and over if you're not improving, if your package is not improving, if your lawyer is not improving on your package. So it's a question that depends on the circumstances. It depends on the case. But sometimes, some people that just keep doing the same thing over and over again, obviously you're not going to win. You're not going to change. So yeah.
That's why looking for a lawyer to do it at the first place is very important.
Yeah, absolutely.
So if the 601A application is approved, is that going to guarantee that I'm going to be granted an immigration visa at the consulate?
Okay, so now we're at the flip side. What happens when you get good news? You apply for the I-601A, you do it right the first time, your lawyer does a good job, and now it's approved. When we talked about this last week, I mentioned that the next step would be to wait for your interview to be scheduled at the consulate, at which point you can safely leave the country so that you can go back to your home country and attend your visa interview at the consulate. Like I said only a few minutes ago, if you have removal proceedings that are admin closed, terminate those before leaving the country. Ask the immigration judge to get rid of the case before you leave the country so that you have no problems coming back. Now, the question is, I-601A approved, does it guarantee that when I go to the interview, I will get a green card? The answer is no. There are no guarantees. There are no guarantees in immigration at all. At the interview, because, it's an interview, that means you have to pass it. You have to answer the questions correctly. The officer has to talk to you and assess you and make sure that you're telling the truth and make sure that your case has no problems. And if you pass the interview, then you get your immigrant visa, then you get your green card. But the I-601A is not a guarantee that interview will be approved too, because that's a separate process altogether, right? The 601A process approval, that when that ends, when you get that decision, when you get that approval, that's one step closer to the green card. The next step, which is the consular processing, is a whole other thing. This is why when I said earlier, the 601A process does not involve an interview. It's still, it's still true, because the interview that you're going to attend is the consular processing interview, which is not part of the 601A process. Separate step altogether.
So if my 601A is approved, what happens now?
Right. So 601A approved, you go back home when your immigrant visa interview is scheduled. And usually you wait a few weeks. Once you're at your home country, hopefully you have some time, because you need to do your medical exam in your home country as well. That's one of the requirements for getting an immigrant visa through the consulate. And you also have to submit some documents like your passport, copies of some civil documents that you need to submit to the consulate. And then you attend your consulate interview and you answer pretty basic questions. And at that point, generally there are no more problems. You've waived all your inadmissibility problems. There is no more problem with unlawful presence. Presumably you don't have a removal order anymore or removal proceedings, because like I said, get rid of that case before you leave the country, right? So you answer the questions and hopefully the consular officer approves you. In some cases, that interview could go wrong. And we can talk about that at some other time, how bad these consular interviews can happen and what kind of problems can arise at consular interviews. But it still does happen. The I-601A approval is no guarantee, like I said. So something wrong could happen, but generally, at least in my experience, in the experience of this firm, because we do everything correctly, once you get to the interview, it's mostly a formality. The officer asks questions, our clients give the answers that we prepare them for, that are usually basic questions about their history and their background, and then they get approved and they're granted the immigrant visa, and within a few more weeks they're back in the US with their green card.
Yeah, that's why you need a good lawyer on this. And actually, our time is up today, so you guys please feel free to leave your question to us.
Right, and please, it doesn't have to be about this particular topic. It can be about any immigration topic. I promise we're gonna try to get to all of those questions at some point. It might not be soon, but we do want to collect them and put them all together in one episode so that everything is related. Again, you can reach us via line, via YouTube comments, via our email, and I hope you reach out to us. As a final note, I keep saying this every time, our YouTube show is not meant to create any attorney-client relationship. I'm giving you my opinion based on my experience, based on very general questions. This is not legal advice. Again, thank you so much for watching, and I hope we see you again next week.
Yeah, you can continue to follow us on the YouTube. Thank you. See you next time.
Bye.